Hey guys, we're still loading here. There we go. Looks like we're live. All right, so it's Tuesday, July the 6th, 3:30. So, and I had the time today, so I'm here. I hope everyone had a good 4th of July holiday, uh, and you're back to work like me after a good 3-day weekend. And so I have some general questions today that I was going to go over. We get a lot of questions about possession of a controlled substance. And it, the problem with many of the questions is they're too general. So, I can give you sort of some general rules about possession. And, first, it has to be intentionally, or it has to be intentional and knowing, right? In order to be in possession of something, you have to either have the intent to be in possession of it or knowingly be in possession of it. And so typically when I'm picking a jury, uh, one of the things that I'll go over with during voir dire with the prospective jury is, a good example is, let's say I walk out in the morning to go to work and my car's got a flat. My neighbor happens to be outside and hear me cussing about my flat and says, "Hey, Mark, listen, I'm not working today. Why don't you take my car since I know you've got to be at court this morning, and then you can just bring it back and fix your tire after court." So, I'm like, "Hey, thanks. I really appreciate it." And so he throws me his keys. I get in his car and I'm headed to the courthouse. Well, I don't know what's in his trunk, right? So let's say that it's possible my neighbor has a kilo of cocaine in his trunk. Well, obviously, I don't know. So the first element, if you will, is not met. I am not intentionally or knowingly in possession of what is in my neighbor's car trunk, right? But the next threshold is the person. Does the person have care, custody, or control of the substance, right? So in that scenario I just gave you, yes, I would have care, custody, and control, right? Because I'm in the vehicle, I'm driving the vehicle, and so therefore I'm in control of the vehicle. So I have care, custody, and control of the vehicle. The problem is my neighbor didn't tell me what he had in the trunk, and so the state can't get a conviction on me without proving that I had knowledge of what was in the trunk. And when I talk to jurors or prospective jurors about this, what I tell them is, if you're not willing to hold the state to their burden on those elements, then you better make sure every time you borrow someone's car or anything like that, that you give a thorough search first. Because if jurors aren't willing to follow the law, then our system falls apart. I have also done silly things in trial before, like walk up to juror number 6 or whatever it was and hand them my briefcase and ask them to hold it for a minute. And then, of course, give the demonstrative that he's in care, custody, and control of my briefcase, and he took it voluntarily. But is he responsible for what's inside my briefcase? And of course, everyone agrees that he or she is not, because they don't know what's in my briefcase. They just took it when I asked them to hold it for me. So that's, a way I like to simplify the explanation of what possession of a controlled substance is. There's a further discussion that we could get into in the future, which is the state has to find affirmative links between the accused and the possession. So, a simple example of that is The police enter a room. There's multiple people in the room. There are drugs in plain sight. I don't know if y'all can see. I have a little table here right beside me, right? So if the police came in here and I had drugs on this little table, I'm the closest person, right? Because I've got a bench over there and I've got guest chairs over there. And so if my office was full and the police came in and I had drugs right here within my reach, the state's going to try to argue that that's an affirmative link to me. We see the same thing a lot in cars. When you have 2, 3, 4 people in a car and the police find drugs, the police will try to articulate exactly where they found it, like under the driver's seat, but in the rear, as if it was the rear seat passenger who would have stuck it under the driver's seat from the rear, or they'll, however they find it, they're going to try and give it to the person in closest proximity to establish an affirmative link to that person or that accused. So that's, you know, as general as I can be on, sorry, I'm having a problem with the comments here. Anyway, that's as general as I can be on possession of a controlled substance. Okay, I got another generalized question about due process. What is due process? You know, due process is the accused must be afforded all his legal protections and legal processes for a prosecution to be held against him. So that means all your rights: right to remain silent, right to a speedy trial, right to a public trial, right to a fair and impartial jury, all the steps of the process before you get to a jury. Every accused is entitled to his due process. So in other words, the state can't just pick you up, not give you due process, meaning allow you through the whole process, which includes giving you exculpatory evidence, right? They can't just rush you through that to trial. You're entitled to your due process and make sure that you have been availed of all your rights before you're forced to a trial. And, you know, the theory of this due process situation is that so no one is rushed to judgment. It's supposed to take, you know, overzealous prosecution out of the equation, so that each accused can have his day in court properly, and having been protected of all his rights. Shorty emailed me and texted me, and he was upset because I wouldn't answer his question. And his question was, how come child molesters get probation even though they've ruined some child's life? And finally I said, you know, Shorty, that's not a real question. And he said, well, what do you mean that's not a real question? And I said, I mean, if you look up the records, very few child molesters get probation. It is very rare that someone who commits a sexual offense against a child gets probation. Does it happen? Yes, rarely. I have gotten it for a client in the past, but the point is it's very rare, and it depends a lot on the circumstances involved, including the strength of the state's case. Here in Galveston County, the prosecutors are very tough on these cases, and like I said, it's very rare that someone who actually committed a sexual offense against a child gets probation. So Shorty, I finally answered your question on here like you wanted me to. We get a lot of questions also about expunctions, and so an expunction is removing a record from your criminal record. So it's removing the arrest, the case, everything. But there's only specific situations where you can get an expunction. That includes a not guilty verdict from a jury, obviously, a dismissal, although the dismissal has to be a certain way, and then obviously a no bill by a grand jury. What people call all the time and say, listen, I got convicted of a felony 10 years ago. I'd like to get that off my record. And, you know, the answer is always the same. Well, if you were convicted, there's not much we can do to get that off your record. Now, there is another process called non-disclosure, which does allow us to seal your record from everyone but the government. So, in other words, if a potential employer did a background check, they would not see it. However, if law enforcement did a check on you, they would see it. District Attorney's Office would see it. Teachers, nurses, just sort of think of everything to deal with the government, and they would still be able to see it. But generally, on a non-disclosure, the public would not. So it is helpful. I got another question here about violation of bond conditions, and that is generally not a criminal matter unless you get filed on for bail jumping, which is not all that common, but it does happen. Typically, your bond conditions, either set by the court or set by the bonding company, are more like contractual issues. So, for instance, we have a court here that likes to drug test everyone who is on bond for a drug-related offense. And so if you, and the judge makes you sign an order stating that you understand and that you will be drug tested. So that has now become a bond condition that you are substance free while you are on bond. And if you test dirty, then there are consequences. So that would be a violation of a bond condition. Depending upon the violation, the state can move against you to have your bond revoked for violating bond conditions. So an easy one there is, let's say it's a victim case, and part of a bond condition is that you cannot have contact with the complaining witness in your case. And if the state can then show that you did or have been contacting the complaining witness, the state can then bring you before the court to have your bond revoked. But it's not a new charge, it's just revoking your bond and taking you back into custody. And many times, at least here locally, when that happens, the courts will typically just double your bond, and you can make bond again the same day. But it doesn't result in a new charge typically, unless you've committed a new offense. And that's another thing. If you commit a new offense while on bond for a previous offense, the state many times, depending upon what court you're in, will file a motion to revoke your old bond for picking up the new case. And obviously we try to fight that and keep you on both your bonds. The other way you could have a bond issue is with your bonding company. For instance, they want you to check in on a regular basis. We get calls frequently from bonding companies saying, hey, your guy hasn't checked in X number of weeks, and we can't get him on the phone. If you can't fix this, we're going to surrender his or her bond. So when that happens, we always find our client and say, hey, you need to get right with your bonding company or you're going to have an issue. And so those are the only way I can see bond conditions affecting your criminal case. Another expunction question. . So I got 3 different expunction questions here, and it says, what crimes can be expunged in Texas? There's not necessarily a type, depending upon the outcome. So whatever the charge is, if you go to trial and the jury finds you not guilty, you're entitled to an expunction. I mean, the simplest way to explain that is if you have been finally convicted, there's likely not a way for you to be able to obtain an expunction. That's about the easiest way I can explain it. Let's see what else I got. That looks like about it. So I hope y'all have a great week. If y'all think of anything you want me to answer in a future live, just feel free to send me an email. I'm sure you know my email is mark@texascriminaljustice.com. You could also do it here through Facebook. I cannot, my comments are off again today, and I don't know what it is that I did to make that happen. So if anyone has made a comment, I'm sorry, I can't see it. But as always, I hope you guys have a good week, and if you think of anything you'd like me to talk about, let me know.